Hi, I'm Dr. Rodgir Cohen. Welcome to class. I would like to begin by discussing the five things that we're going to go over today in the lecture. We're going to look at constitutional sources of civil rights, the equal protection and due process clauses, the 14th Amendment. We're going to describe three tiers of judicial scrutiny and identify classifications that trigger them. We're going to trace the racial rights movement from Plessy versus Ferguson through Brown. We're going to analyze affirmative action development, and we're going to look at LGBTQ plus rights from Lawrence through Bostock. The 14th Amendment, ratified in 1868 in the aftermath of civil war, is the constitutional foundation for modern civil rights law. The Equal Protection Clause, that no state shall deny to any person within its jurisdiction the equal protection rights and laws, commands states to treat similarly situated people similarly. The Due Process Clause provides an additional avenue for civil rights claims through the concept of substantive due process. The critical limitation was the 14th Amendment applies only to state action, action by government actors, government employees, institutions acting under the color of law. It does not, by itself, prohibit private discrimination. A restaurant owner who refuses to serve black customers because of race is not violating the 14th Amendment. They are violating the Civil Rights Act of 1964, which is a federal statutory law enacted under the Commerce Clause. Private discrimination is addressed through federal statutes, not the Constitution. The Fifth Amendment's Due Process Clause applies as an equivalent equal protection requirement to the federal government through Bowling versus Sharp in 1954, decided the same day as Brown versus Board of Education. The court could not logically say that segregated schools were unconstitutional in states while permitting them in the District of Columbia. There are three tiers of judicial scrutiny. The three tiers of judicial scrutiny are the analytical machinery through which courts evaluate equal protection claims under the law. The tier that applies and depends on what kind of classification is being challenged. Strict scrutiny applies to suspect classifications like race, national origin, and alienage, and to laws that burden financial fundamental rights. When strict scrutiny applies, the government must show a compelling government interest that is served by means that are narrowly tailored to achieve that interest. Strict scrutiny is, in practice, nearly always fatal to the challenged law. Hence the description strict in theory, fatal in fact. Rationale for treating race as a suspect classification is the history of legal imposed racial hierarchy. Race is a characteristic that bears no relationship to ability or merit, that has been the basis for a long history of purposeful unequal treatment, that is a viable, immutable characteristic that subjects its possessors to stigma. Immediate scrutiny applies to quasi suspect classifications, primarily sex and gender, and requires the government to show its classification is subsequently related to the important government interest. This is more differential than strict scrutiny because more demanding than a rational basis. The intermediate tier reflects the court's judgment that sex discrimination is serious, but that sex based classifications sometimes serve legitimate purposes that race based classifications cannot. The rational review basis review applies to all other classifications and is enormously differential. The classification must bear any conceivable national relationship to a legitimate government interest. So courts virtually never strike down laws under rational basis review, even though the classification seems arbitrary. The result, most economic and social legislation, including laws that create significant distinction between groups, survives constitutional challenge. So the intent requirement is important to understand. Washington versus Davis in 1976 established the most consequential limitation on civil rights constitutional doctrine. Discriminatory effect alone is not sufficient to trigger heightened scrutiny. A plaintiff must prove discriminatory purpose, intentional discrimination by a specific government actor in a specific case. The consequences are profound. Statistical evidence that a policy produces racially disparate outcomes is not sufficient. You must show that the disparity was intended. McClemsky versus Kemp in 1987 is the most disturbing application. Warren McClemsky presented a sophisticated statistical study by Professor David Baldus showing that black defendants in Georgia were significantly more likely to receive the death penalty for killing white victims than white defendants for killing black victims, even after controlling for 230 other variables. The Supreme Court held that even if the pattern was real, McClemsky could not establish a constitutional violation without proving that the Georgia legislator or the specific prosecutors in this case acted with a discriminatory purpose. So, this brings us to this actual question that we must ask ourselves. Um, if we're asking ourselves, what evidence of discriminatory intent is sufficient then under Washington versus Davis? The answer the court requires proof of explicit racist motivation by specific decision makers in a specific case is nearly impossible to find discrimination that operates through institutional structures, an implicit bias rather than explicit racial statements. Historically, we have to look at the racial civil rights timeline. Dred Scott versus Plessy was legal apartheid in America. Dred Scott versus Stanford in 1857 is the worst Supreme Court decision in American history. Chief Justice Taney held that no black person, free or enslaved, was a citizen of the United States or entitled to the rights and privileges of citizenship. Enslaved persons were property, and the Missouri Compromise that had restricted slavery in territories was unconstitutional because it deprived slaveholders of their property without due process. The decision was a major contributor to the political conditions that gave us the Civil War. Reconstruction period happened and produced the 13th, 14th, and 15th Amendments, abolishing slavery, establishing birthright citizenship and equal protection, and prohibiting denial of the vote on the basis of race. For a brief period, Black Americans voted, held office, participated in civic life throughout the South. The political deal that ended Reconstruction in 1877, the Hayes-Tyden Compromise that resolved the disputed 1876 presidential election, withdrew federal troops from the South and abandoned Black Southerners to the mercy of state governments. The result was the Jim Crow system. The Jim Crow system instituted poll taxes, literary tax, grandfather clauses, white primaries, convict leasing, and pervasive racial terror. Plessy versus Ferguson in 1896 gave it a constitutional sanction. Separate but equal facilities are constitutionally permitted, it said, and that racial apartheid had the approval of the Supreme Court for 60 years after this. The NAACP had a strategy, and with the Brown versus Board of Education, the NAACP was the legal defense fund strategy for dismantling Plessy. It was a masterpiece of long-term planning. Rather than attacking separate but equal directly, a losing proposition with the Supreme Court in the 1930s and 40s, Thurgood Marshall and his colleagues argued that the separate facilities were manifestly not equal, forcing states to spend enormous sums equaling up or abandoning segregation. They deliberately built their record in law schools and graduate programs where the inequality argument was hardest to escape. Brown versus Board of Education, 1954, is the most important Supreme Court decision of the 20th century. Justice Warren's unanimous opinion held that separate educational facilities are inherently unequal. Separate segregation itself, regardless of the physical facility comparisons, generates a sense of inferiority that damages Black children's educational development. The sociological and psychological evidence Marshall presented, Kenneth Clark's doll studies, among others, was embedded in opinion. Separate is inherently unequal. Brown's implementation was tortured. Brown, too, in 1955, ordered the desegregation with all deliberate speed, and a phrase critics noted was designed to permit delay. This led to the Little Rock crisis in 1957 that required President Eisenhower to send in the 101st Airborne Division to enforce a federal court order over the resistance of Governor Phoebus. A massive resistance by Southern states persisted for decades, and the full promise of Brown was not realized in most Southern school districts for 15 to 20 years afterwards. The civil rights movement legislation strategy combined with other legal challenges with mass direct action designed to take the cost of maintaining apartheid to the economy, to the United States Cold War credibility, and to domestic stability was high enough, that cost was high enough that Congress would act. The Montgomery bus boycott in 1955 and 6, the Greensboro sit-ins in 1960, the Freedom Rides of 61, the Birmingham campaign in 63, and the March on Washington in 63 escalated pressure and generated national media coverage. The Civil Rights Act of 64 and the Voting Rights of 65 was a legislative culmination. The Civil Rights Act prohibits discrimination in public accommodations and employment on the basis of race, color, religion, national origin, and sex. The word sex was added by the Virginia congressman who thought it would kill the bill. The VRA used Congress's 15th Amendment enforcement power to require federal preclearance of voting law changes in states with a history of discrimination, effectively dismantling the infrastructure of voter suppression. We start to look forward to modern times. We see the George Floyd murder in 2020 of a white Minneapolis police officer that knelt on the neck for 9 minutes. And when he said, "I can't breathe," produced the largest sustained protest in American history, with an estimated 26 million Americans protesting from Derek Chauvin and George Floyd. The political backlash from this is still being felt from changes within DEI, changes within school, and government programs over what civil rights means in the modern era today. The affirmative action was the rise and fall of affirmative action was the university's admissions developed a response and recognition to formal desegregation was inefficient, and the centuries of legally enforced disadvantage created barriers of equal to equal education opportunity that would not be removed simply by opening the door. So, Regents of California versus Bake in 1970 produced a fragmented court with no majority opinion, but Justice Powell's controlling opinion established a framework that governed 25 years. They'll have fixed racial quotas that are saying that fixed racial quotas are unconstitutional, but race may be considered as one of the factors among many in holistic admission process that seeks educational diversity. By 2003, the Grutler versus Bollinger case upheld the University of Michigan law's race-conscious admissions program in a 5-4 decision over Justice O'Connor. The court held that student body diversity is a compelling government interest, and that O'Connor's majority included a remarkable prediction and expected that race-conscious admissions programs would no longer be needed in 25 years by 2028. Students for the fair admission of Harvard's and fair admissions of North Carolina in 2023 overruled Gruther in a 6-3 decision by Chief Justice Roberts. The majority held that Harvard and UNC's programs violated equal protection clause because they lack measurable objectives that allowed them to be limited in time. So, what's permitted now? The Roberts majority was careful to identify what universities may still do. They may consider how race has affected the applicant's life through discrimination, inspiration, and otherwise, as part of a genuine individual assessment. What they cannot do is mechanically treat race as a factor in admissions decisions. The line between a holistic program that gives weight to an essay about governing racial discrimination and a program that uses race as a factor in genuinely difficult to review and draw, the lower courts are currently resolving this right now. The women's right movement and the LGBT plus movements are issues on the fore right now. The 19th Amendment ratified in 1920, after more than 70 years of organizing and extending the women's right to vote, the achievement required the sustained organizational effort of 2 generations of suffragists who overcame opposition from both sides. Most state legislators and a culture that regarded political participation by women as inappropriate and dangerous were the problem here. So the Title VII of the Civil Rights Act of 1964 prohibited employment discrimination based on sex, as well as race, color, religion, and national origin. Title IX in 1972 prohibited sex discrimination in educational programs receiving federal funding, and the basis of women's athletic programs and sexual harassment protections in universities was applied. The Equal Protection Pay Act of 1963 requires equal pay for equal work, and though the gender pay gap was existing and still existed for many years and still does to this day, women earn approximately 84 cents to every $1 earned by men. The Equal Rights Amendment declared that the equality of rights under the law shall not be denied or abridged on account of sex. It was passed by Congress in 1972 and ratified by 38 states, reaching the three-quarters threshold by 2020. But it was not ratified within the deadline Congress set, and the legal question of whether it is now part of the Constitution remains unresolved. Several states have attempted to rescind their ratifications, so the Equal Rights Amendment seems to be dead in the water. The LGBTQ plus civil rights movement, Lawrence versus Texas in 2003, overruled Bowers v. Hardwick in 1986 and held that the Due Process Clause protects the right of consenting adults to engage in private same-sex intimate conduct. The government had no legitimate interest in criminalizing what happens between consenting adults in their own homes. So Oberfeld versus Hodges in 2015 extended the fundamental right to marry to same-sex couples, holding that denying marriage licenses to same-sex couples violated the due process and equal protection clauses. Justice Kennedy's majority, the right to marry is fundamental because it enables two people to commit to one another in a lifelong relationship that confers dignity and legal recognition. We see by 2026, the battleground for more than 20 states have enacted transgender sports bans, restricting participation in women's constitutions, and these are coming into contest with federal laws through this time that we have right now. I'd like to thank you for turning into this lecture.